West Coast. My name is Mark Weiner, and I'm litigation counsel with Everytown Law, and we'll be leading the panel discussion today. For those that don't know, Everytown Law is the litigation arm of Everytown for gun safety. And among other things, we represent numerous cities in court in order to advance and defend gun violence prevention measures. So we have recently issued national guidance on how to prevent and respond to armed intimidation at the polls and during ballot counting. Thank you to all of you for joining us today about that urgent and pressing topic that I know we are all deeply concerned about, preventing and responding to illegal armed voter intimidation and election interference. This webinar is co-sponsored by Prosecutors Against Gun Violence, and I'd like to thank the chairs of PAGV, Los Angeles City Attorney Mike Fuhrer and Manhattan District Attorney Cy Vance for putting this together. A few quick logistics. First, DA Vance will give us some open remarks, and then I'll be engaging District Attorney Torrez, Mary McCord, and Josh Horowitz in a conversation over the next 40 minutes or so. And then we will have 15 minutes for questions from all of you at the end of our discussion. Everyone, except for the presenters, is currently muted. Feel free to share your questions at any time in the Q&A box. Just click on the Q&A icon. I'll keep track of them and I'll ask when we open it up for questions of the presenters. And if we don't get to all of your questions, we will follow up with you afterwards. You'll also be able to raise your hand during the Q&A using the raise hand button or *9 if you're calling in by phone to verbally present your question. This conversation will be recorded and we will make available all of the materials that we're going to be discussing today in case you haven't already seen them. I also want to let you know that we do have some reporters listening in today who may want to write a story about the information presented and some of the actions we're encouraging you as prosecutors to take to address this issue. That said, if you prefer to submit any of your questions or comments anonymously, you're welcome to do that. You select the Q&A icon, and on the bottom left, you will see that you can check Submit Anonymously. So with that, I'm going to hand it over to DA Vance to provide some opening remarks and introduce our panelists.
Mark, thank you very much. Mike, good to see you from the East Coast to the West Coast, and welcome, ladies and gentlemen. Thank you so much for participating in today's important seminar. We have with us this afternoon district attorneys and senior leaders from some of the country's most preeminent prosecutors' offices and gun violence advocacy organizations. And they come from red states, blue states, and swing states. And although today's topic of preventing and responding to illegal armed voter intimidation and election interference is centered around something highly political, the upcoming presidential election, today's discussion is not about engaging in partisan politics. It's about seeking to deliver greater public safety to our constituents and to our stakeholders, which is what Prosecutors Against Gun Violence is all about. We're going to begin our panel discussion on the actions you can take to prevent and prepare for armed intimidation at the polls and ensure that your residents feel safe exercising their right to vote in your communities. It's a serious topic and sad that we have to actually address it, but I am glad that we have these experts here today who can speak to us from a national perspective to each of us in our various jurisdictions. We have a distinguished panel of experts, and I'm delighted that we'll be speaking with District Attorney Raul Torrez, a friend and fellow district attorney from Albuquerque, Mary McCord, and Josh Horowitz. District Attorney Torrez has been the chief prosecutor in Albuquerque, New Mexico since January of 2017. In his administration, he has undertaken groundbreaking work to reinvigorate the role of the district attorney's office in public safety and in the community. As an example, this past summer, in collaboration with Mary's organization and a private law firm, Raul filed a civil suit to protect the public against a private militia, the New Mexico Civil Guard, challenging the militia's unlawful presence at protests. This was the first civil suit against a militia organization ever filed by a district attorney. An important step. Previously, he served as a federal prosecutor and also as a senior advisor in President Obama's Justice Department. Thank you, Raul. We're also joined by Mary McCord, who is the legal director of the Institute for Constitutional Advocacy and Protection, or ICAP, at Georgetown Law Center, my alma mater. Mary and her team have developed an unmatched expertise in addressing the rise of unlawful private militias, and they are also at the forefront of constitutional advocacy and litigation on police and criminal justice reform, voting rights, and many other critical issues. Mary was the Acting Assistant Attorney General for National Security at the U.S. Department of Justice from 2016 to 2017, and the Principal Deputy Assistant Attorney General for the National Security Division from 2014 to 2016. Prior to that, she served for nearly 20 years as a federal prosecutor in Washington, D.C., with roles including Chief of the Criminal Division and Deputy Chief of the Appellate Division. Mary, thank you so much for bringing your expertise here today.
Thank you, sir.
I'd also like to introduce Joshua Horowitz from the Coalition to Stop Gun Violence. Josh is the Executive Director of the Educational Fund to Stop Gun Violence. He has spent more than 3 decades passionately working on gun violence prevention issues. In 2013, Josh was one of the founders of the Consortium for Risk-Based Firearm Policy, a group of mental health and public health experts who have examined the intersection of guns and mental health. The consortium released a set of policy recommendations that provided the basis for California's first in the nation gun violence restraining order law, AB 1014, that passed in September of 2014. Josh is a visiting scholar at Johns Hopkins Bloomberg Public School of Public Health, where he teaches public health advocacy. And to moderate the discussion, we are joined by Mark Weiner from Everytown Law. Mark litigates on behalf of Everytown's clients, primarily focusing on representing clients to defend or further gun violence prevention measures. Prior to joining Everytown, Mark was a senior litigation associate at Pryor Cashman, LLP, where he focused on complex commercial litigation, investigations, and white-collar criminal work. And with that, Mark, I will pass it back to you.
Thanks so much, District Attorney. Let's get started. Elected officials, and especially local prosecutors, have tools available to help ensure a safe and successful election. As I noted, Everytown recently issued a fact sheet to give local elected officials a roadmap to help prepare. We set out what we think are the most important legal protections against voter intimidation and armed intimidation that already exist, and we linked to separate guidance that Mary and her team have issued for each state on unauthorized militias. And then we go and talk about some of the steps to take now to help voters have a safe and protected experience when going to the polls, as well as election officials over the next few weeks. Similarly, the Coalition to Stop Gun Violence, working with advocacy group Guns Down America, also recently published a report around armed intimidation at the polls. That report looked at the ability of 5 states, Michigan, North Carolina, Pennsylvania, Virginia, and Wisconsin, to limit guns at polling places. We will be sending along electronic versions of these reports to everyone after the presentation. The bedrock of each of these reports is the recognition that exercising one's franchise is fundamental to our democracy and that we all want to maximize voter participation. We don't want to amplify at the same time what we hope is a small possibility and have it deter people from voting. So in addition to prioritizing prevention, we should be reminding the public that voting is the bedrock of our democracy and that all of us are working to ensure that it is safe. So I think that's a useful starting point to frame our conversation today. And I'd like to start by asking District Attorney Torrez, what kinds of things are you most concerned about in terms of voter intimidation in Albuquerque as Election Day approaches? And how are you managing this tension with not wanting to inadvertently amplify those issues among the wrong folks? And any specific strategies you have to communicate with the public about voter intimidation?
Sure. First, let me say thank you to Mike and to Cy and to Prosecutors Against Gun Violence. I think it's extremely important that we bring everybody together and really talk about practical solutions to some of the most difficult and challenging things that I think we as local elected officials are going to face in the upcoming weeks. In terms of the starting point for what I think all prosecutors should be thinking about, ensuring that we have free and fair elections, is to start, if you haven't already, communicating directly with your law enforcement partners and offering very specific and detailed guidance on what the protections are in your specific jurisdiction. We started with that here in Albuquerque. We reached out to the local police department and the sheriff's department, put together a comprehensive virtual training, and not only for our in-house prosecutors, but also for our law enforcement partners, because to be perfectly honest with you, very few frontline prosecutors or patrolmen are going to know exactly what the election laws provide in terms of the protections or the criminal penalties and sanctions. So it was important for us to get organized internally and with our law enforcement partners. We conducted that training just this last Tuesday and have made it available online to all of our partners so that they can go at their own convenience and be ready. We also let them know that we're going to be staffing effectively a war room of prosecutors in my office and investigators in my office who are going to be available when early voting starts here in Albuquerque tomorrow through the end of the election. We've had some limited early voting at a couple of polling sites, but it goes countywide starting tomorrow. So we're going to stand up this basically 1-800 hotline for our law enforcement partners so that people and officers, if they're called out to a polling site and they have, difficult questions that they need to answer about, does this constitute voter intimidation, or is it obstruction, or is it simply disorderly conduct? We're going to have real experts available in real time to answer those questions and give them guidance, because we don't want officers feeling like they're trying to make these snap decisions on the fly. We emphasized during that training, I will say, our intention is not to maximize criminal cases, arrests, or referrals to my office. It's my belief that we can actually have informed officers working with our prosecutors that can engage directly with the public, sometimes people who are violating the election law, and they can say, we're here to de-escalate this situation. We think you might be in violation of this code, and we're going to ask you to step back. And then we can give them a specific framework and script that they can use to try and de-escalate the situation, because we're cognizant of the fact that even making an arrest at a polling site is in and of itself potentially very disruptive and could suppress the vote there. So our goal, again, is not to maximize cases. It's to provide as much frontline early information as we can to our stakeholders. With regard to your question about how we deliver this message without amplifying or provoking responses, we've started by engaging with local media. We use, obviously, the tools that we always use in our office in terms of engagement, social media engagement. We're running now discrete posts about this is what voter intimidation is under New Mexico law. It's a 4th-degree penalty. We're prepared to investigate it. We're prepared to respond. What we're not trying to do, though, is invite an antagonistic situation, and so we're very careful. And the last piece, which is something that I mentioned with the mayor's group that we talked to last week, is when it comes to armed extremist groups, I talk about them and do my level best to talk about them as armed extremist groups and not as militias, because as Mary and the folks at ICAP can explain to you, there is a sense in this country, there's a historical framework, that militias are some group of people who are empowered to go forth and protect fellow citizens and protect the state, but that's a highly regulated space. So in terms of framing, these aren't militias. These aren't people that are waiting for Paul Revere to come through and have a call to arms to defend fellow citizens and property. These are armed extremist groups, and they need to be talked about in those terms. And we do our best to try and do that. So there are a number of communication techniques that we use, but the real important point is early engagement internally in your office and with law enforcement partners. And the last point I would make, and I would leave this up to Mary to sort of fill in the gaps, is we are not experts. I'm assuming that most of the prosecutors on this call are in new territory when we're talking about this. That's why I always recommend people reach out to the Institute for Constitutional Advocacy and Protection. Mary and her team can give real clear and specific guidance on the parameters of First Amendment rights on assembly, your Second Amendment rights in the context of perhaps you live like I do in an open carry state, and how the interplay between all of those, constitutional framework that has been set forth, how it works in conjunction with your local election laws. And it's important to rely on them as a resource. And it's incredibly relieving for somebody in my position to be able to call on somebody like Mary and say, we're in new territory here. What do we do? So if you haven't looked at the ICAP site and looked at the fact sheet, I strongly encourage everyone to do that.
Thanks so much, District Attorney Torrez. That's a perfect transition to my next question for Mary. You and your organization have long led the way on this issue of unlawful or unauthorized militias. Can you start out by telling folks just a little bit about what militias are, why it's important for us to be talking about them now, and some of the laws on the book to combat them?
Sure, and thank you for the nice comments, Raul, and thank you again to everyone for being here today, because I think these are really important topics this year, is particularly fraught. We got into this business after the Charlottesville Unite the Right rally in August of 2017. I had just left the National Security Division at DOJ, and when we saw the heavily armed unlawful militia activity at Charlottesville, we thought something's wrong with that. We need to do something about it. And that's what started our niche expertise in this anti-militia area. We used state law prohibitions on militias to bring a lawsuit on behalf of the city of Charlottesville, local residents and local businesses to get court-ordered injunctive relief against militias, not to prevent them from coming back and expressing their speech or their viewpoints, but from engaging in this armed, coordinated use of force or projection of the ability to use force during protests and rallies. And that's what sort of started this off. So we've seen since then, and particularly this year, this increasing public presence of these private militia groups. And Raul's right. I either say unlawful in front of them or vigilante in front of them, or better yet, armed extremist groups. It's particularly for those who harbor in particular extremist views. We've seen their increasing public presence this year in two ways. One is sort of the offensively joining together well armed in opposition to government policies. And we've seen that in Michigan and Ohio and Idaho and elsewhere, where they are in opposition to public health orders like shutdown orders, masking orders, etc. We've also seen them taking up more of a defensive posture where they would purport to augment law enforcement and protect property, protect statutes, etc. during racial justice protests, usually in response to just blatantly false information about violent anarchists coming to engage in rioting and looting. And oftentimes we're talking about like a high school sponsored Black Lives Matter demonstration, entirely peaceful, that then has to encounter heavily armed groups of men at street corners, in some cases even stopping cars, really just usurping law enforcement authority, totally outside of public accountability. So because of what we've seen, and oftentimes, frankly, responses to some of the dog whistles coming from the White House, is some concern that given the disinformation right now about election fraud and the potential for election fraud, disinformation that was disabused by FBI Director Chris Wray in his recent testimony, saying we've seen no evidence of widespread voter fraud, but notwithstanding that, that disinformation is out there. So we do have some concern that some of these armed extremist groups will take it upon themselves to deploy to protect against voter fraud or to protect against election fraud, both in early voting, on election day, and then, you know, potentially also deploy thereafter if there is some delay in tabulating the votes or if they are dissatisfied with the result. And I can talk at some point about the intelligence we've got on that, because we are working with researchers that are providing information about sort of the extent of this threat. But the 3 points I want to make before we get to that, because I want everyone to remember this, and this is stuff I never knew when I was prosecutor. I've learned this since then, is first, there is no federal or state authority under law for private groups of individuals to arm themselves and self-deploy as a private militia. So they will often point to the language of the Second Amendment, a well-regulated militia, and say, well, we regulate ourselves, that's our authority. But well-regulated means regulated by the state, It has always meant that even before the founding, even when we were in the time of colonies, when the colonies did not want to have a standing army, they instead decided they would have a militia, which was defined essentially to be all able-bodied persons between certain ages who were available then to be called forth in defense of the colony on behalf of the governor or the leader of the colony. And that is how they provided for their own defense pre-independence. That was then baked into the US Constitution with the well-regulated militia clause, and it's been baked into the constitutions of most states who have a similar provision. And so it is only the governor in every state who has the authority to sort of call forth this body of people as a militia. And when called forth, they report up through the state government, never on their own. And of course, over time, through statutory enactments, you know, the modern militia is the National Guard. And then some states also have a supplementary state militia. So we don't really use this calling forth the militia anymore, but a lot of times those fragments are still within state constitutions. But always the only, I mean, to remember nothing, the only legal militia is a state militia. So point one, no authority under federal or state law. Point two, the Second Amendment does not protect paramilitary organizations. So many people will point to the Supreme Court's decision in 2008 in District of Columbia versus Heller that held for the first time that individuals have a right to bear arms for their own individual self-defense. They'll put that in combination with an open carry state, and they'll say, voila, that is our authority to band together as an organized group and carry firearms in public. Not just carry firearms in public, but project authority, armed authority in public. But the Second Amendment, for all of the gray areas in it, has actually been interpreted by the Supreme Court in a way that's very crystal clear when it comes to private paramilitary organizations. In 1886, the Supreme Court upheld a state statute in Illinois, which exists there still and on the books of 29 states, that bars bodies of men from associating together as a military unit or parading or drilling in public with firearms. The Supreme Court upheld that statute in a prosecution against constitutional challenge, saying it is without question that states have to be able to prevent paramilitary organizations in order to further public safety, peace, and good order. 2008, when the court decided the District of Columbia versus Heller case, it contrasted this individual right to bear arms for self-defense with paramilitary organizations, again, reiterating its holding from 1886 and saying that the court was clear then, and no one has even argued otherwise, that the Second Amendment does not prevent states from banning paramilitary organizations. So that's point two, Second Amendment doesn't protect it. Point three is every state bans or does not authorize private paramilitary organizations. 48 states have baked it into their constitutions. The military in all cases must be strictly subordinate to the civilian government. And as Raul said earlier, every state heavily regulates militia activity, and the only lawful militia is a state militia. 29 states have the statute I just talked about that was upheld back in 1886. It was a post-Civil War Reconstruction era statute, which makes sense. We just come out of a civil war. Governors didn't want to have to deal with rogue militias. That exists still in 29 states. 25 states bar the training, instructing, demonstrating, or practicing in the use of firearms, incendiary devices, and in most cases, other techniques capable of causing bodily injury or death for use during or in furtherance of a civil disorder. So those are things that allow you to actually, you know, look into training camps, for example. In fact, these statutes date to the late 70s, early 80s when the KKK was starting to open up a lot of training camps, and there were prosecutions under those statutes at that time, but then they statutes sat on the shelf and got dusty and people forgot about them. Another approximately dozen states also prevent, including New Mexico, and Raul's using this statute in his civil enforcement action right now against the New Mexico Civil Guard, prevent the false assumption of the functions of a public officer, peace officer, law enforcement officer. So even if you don't have a fake badge, just assuming those functions is unlawful. And in fact, just today, an unlawful militia member who had been in New Mexico at the border, along with his unlawful militia members, unlawfully detaining migrants and holding them for Customs and Border Patrol, was prosecuted last year for falsely assuming the functions of a public official, Customs and Border Patrol officer. Just today was sentenced to 21 months in prison for that offense. So these statutes do have real teeth. And so the 3 points again are: no lawful authority under federal or state law. Second Amendment doesn't protect it. All the states prohibit it. And I'm happy to take questions later today, or certainly respond to any questions you might have going forward as you consider your options and what kind of things, how this might impact activity at the polls as well as afterwards.
Thanks so much, Mary. And Mike Mead posted in the chat box there the paramilitary and militia state fact sheets that Mary's organization has put together for each individual state. So definitely take a look at those for your state. And we will definitely want to get back to you about this intelligence that you gather. But before we do that, I'd like to turn to you, Josh. In the CSGV report on voter intimidation, you advocate for state and local legislatures to ban firearms at polling places, but you also identify alternative legal remedies in each state you examine. What are some of the laws outside of banning guns at polling places that prosecutors might look to protect voters against armed intimidation?
Yeah, thanks. That's a great question. And thank you very much for having me. I really appreciate it. So there's a couple of different places to look for these. So the number one is, what are the state's voting harassment laws? So for instance, there's always spatial limits on where people can actually stand and try to influence voters. In my home state of Virginia, I just actually did the training last night. It's 40 feet. More importantly, it is not possible within the polling center itself. So 40 feet from the door, and then inside the polling location, the poll watchers have to be trained. They have to have the training before they go, and they cannot interact with voters. So it's something that each state will have their own law about the sanctity of the voting location, with very distinct spatial locations where harassment can occur. The other place is, what is the law of the actual physical location of where the voting is taking place? So for instance, schools, for instance, schools may prohibit it, even people with concealed carry from coming on. Churches, private property may prevent people who are armed from coming into their buildings. So knowing the law, and also what the property owners are thinking at the time, and what their policies are very important. So that's one thing. There's also just pure harassment, firearm brandishing, things like that. There's a body of law there, and if there's an intent to intimidate, that's part of it. The other thing that we're finding, and I would encourage people to get guidance from the Secretary of States. So in Virginia, the Secretary of State has just put out a guidance. Michigan just followed today. Michigan made it clear, no open carry at the polls. Pennsylvania, for instance, because they have a state of emergency about COVID, you're not allowed to open carry right now in Pennsylvania. So knowing the state laws in this particular circumstances of your state are very important. And I would actually encourage you to reach out to your Attorney General or Secretary of State for guidance. And when you talk about messaging, one of the things is the Secretary of State saying, we're here to help. We are here to make these voting areas secure, but here's the law of what needs to be done. The other point is really close connection with your local election officials, and because they will have issues that come out through the day. Knowing that, and a lot of the people who run the precincts, but especially who are the sort of precinct captains, the people who run multiple precincts, especially for depending what party, for those precincts, they will know the law. There's actually some really good detailed guidebooks put out that I just learned about as I was being trained last night from elected officials about what the law says. And so if you can get your hands on that in your jurisdiction, you'll get a really good primer for what's allowed and what's not allowed. But having that close relationship with the elected officials is going to be important. So looking at the spatial, the distance requirements is important. Knowing the location requirements is important. Knowing the law about concealed carry and open carry are very important as well. Most states do not prohibit guns at the polls outright. So that's something that, you know, if you have a concealed carry in some states, and you don't show it, you don't brandish it, that's legal in most states. But there's a whole other suite of behavior, especially going back to what Mary was talking about, the intimidation factors and people showing up together with open carrying of weapons. There's very prescribed places they can be, and they cannot get within certain distances of polling places. And if there are there's no such thing as like these unauthorized poll watchers have no special rights. They don't get to go inside. They don't get to harass voters. They don't get to look at voting books. So understanding what your jurisdiction allows and doesn't allow, so that you can, I think, well, you mentioned this, come out and let people understand what the law is, what the expectations are, can solve a lot of problems. So knowing your local law is going to be extremely important. There are, of course, federal prohibitions. I think for most of the prosecutors on this, they're going to be looking at state law. But again, there's just a suite of laws that I would really want to know well before Election Day.
And I want to just pick up on one thing that Josh mentioned. And we're actually collaborating with our county clerk. She maintains a master list of every judge that's supposed to be at every location, along with the designated watchers that have been selected by the respective parties and the challengers. That master list serves as the definitive guide for an officer showing up at that location. So if your name is not on that list, as provided to us by the county clerk, we know instantly who is supposed to be in there, who's authorized to be in there, and who's not authorized to be in there. And so that's the kind of level of logistical detail that I think prosecutors should, if they're going to engage in this kind of preparation, that's the kind of thing that you're going to be looking for, is give me the list site by site, location by location. And then I can even take the next step of sharing some of that information with area commanders in my police department, so that if and when they get dispatched to a location, before they even get there, they know the name of the election judge. They know the right person as designated by the county clerk, who can definitively say who's entitled to be in that polling location. The other thing that we stressed in our training, and I think even though this is about paramilitary groups, it's important to have this in mind. The presence of police officers themselves can serve as a deterrent to people, especially in minority communities, who have a long legacy of perhaps law enforcement acting as a form of deterring their participation because of the historical legacy. We make it very clear to our officers that this is supposed to be a civilian-run process, as coordinated by the Secretary of State and the county clerk. And so that you are there, if called upon by the presiding judge at the polling location, to step in if they can't resolve a problem. But police officers themselves, frankly, are not supposed to be physically present in the location unless they're requested by the presiding judge. It's different when you go outside of the location, because then you may have members of the public who are observing activity outside of the location that may be triggered by the spatial and distance limitations that Josh talked about. And so they have to be able to understand the difference between what happens inside the polling location and behavior that's occurring outside the polling location.
Thanks so much. That's really helpful. And I would add to what Josh was saying, every state has some sort of voter intimidation law. And I think that you definitely find them on the Everytown fact sheet. There's a couple of very long footnotes where we lay out each state's voter intimidation law. And of course, every state, as all of you are aware, have armed intimidation laws, just unrelated to elections, just generally. It's always, of course, unlawful to intimidate somebody with a firearm. And so those can be applicable as well. And I wanted to bring that question back to you, Mary, and also maybe take this opportunity to tell us a little bit about the intelligence that your organization has gathered. Oh, you're on mute.
You think I know better by now. So we've been working with not only researchers who pull data from open source reporting and a variety of tools to see where hotspots for political violence is, but we also are working with researchers who are scraping social media to see what kind of activity is being discussed. And there are three buckets, and I've just recently been briefed on this by a couple of researchers from a couple of different organizations. And the chatter that they're seeing is, and I've actually heard from a lot of reporters about this, reporters who call me, and they've just been talking to various, armed vigilante militia members about their plans, and they've shared it with me. Not always by name, but the general information. So we're hearing about plans to send small groups of armed paramilitary members out to polls in, I can't tell you what places, but I think their thought was that they might have a lower profile and be less inclined to draw law enforcement attention if they're coming in groups of 2 or 3 well armed, as opposed to in a big group of a dozen or 20 or 40 or 50. We're also hearing, and in fact, the leader of the Oath Keepers just recently made a very big public statement in Georgia about gearing up to send people to the polls on election day. And that's an organization, if you're not familiar, that does have a nationwide presence. We are also hearing that some of these organizations are recruiting people to actually be poll watchers who are qualified to go in the polls. So in every state, the law is different about who is entitled to go inside the polls and observe. In some states, they're called election observers. In some states, they're called poll watchers. And in some states, it's a very minimal qualification. Sometimes only certain people can do it. So you need to know your own state's laws on this. But the idea would be that some of these groups are mobilizing to have their people be poll watchers, and then just, what I was told, muck up the works, challenge people's qualifications to vote, challenge other things happening just to slow down the process, just to create some turmoil that makes it difficult for election workers to do their jobs. And then third, what we're hearing, probably more than any of the first two, is about increased musters. That's what they'll often call their gatherings, musters and trainings for post-election. Now, some people are being extremely, extremely extreme and talking about civil war, etc. Others are not necessarily using that type of hyperbole, but are talking about, we've been mustering like crazy, and this is even at like the county level, to be prepared post-election for whatever types of civil disorder or riots might be in the street. So I think, as district attorneys and then, law enforcement professionals, this is why it is so important not only to get prepared for the election, but what might come after, and really sitting down between USDAs, your police chiefs, your sheriffs, if you work with sheriffs in your jurisdictions, your mayors or city councils, and your election officials, and preferably also community leaders, and kind of get on the same page about the type of statements you want to make to encourage people to come to vote, and not be intimidated, have their back, and have a plan denouncing any type of violence. And sometimes, as Raul said, law enforcement themselves can be intimidating. So that's why I think the importance on a community by community basis to also use faith leaders, other respected community leaders for this messaging is so important. We are working right now on what we hope to be like another 1 to 2 pager, like front and back, that gets a little more granular about what law enforcement can do when they see a group or even an individual who's armed, like outside the no electioneering zone. Josh was talking about the no electioneering zone, where you can't do any leafleting or campaigning within that zone. Sometimes it's as little as 10 feet in Pennsylvania, sometimes it's as much as 200 feet. But it doesn't mean that outside that zone it's a free-for-all and you can intimidate, because voter intimidation is unlawful everywhere. And so part of the idea is to give some granular guidance to law enforcement and election officials about what they can do if they see armed groups either inside or outside the zone. Things like, you can always have a consensual encounter, like, hi, what are you doing here? If they say, we're here to protect the vote, well, you have no authority to protect the vote. Why don't you take your guns back to your car? Why don't you, why don't you step back, because you could be scaring people. You've got assault rifles. If they say, well, we're here exercising our First and Second Amendment rights, well, again, voter intimidation laws are important parts of our statutory schemes, and they represent a significant and compelling governmental interest in preventing voter intimidation, which the Supreme Court has said in the context of upholding these no electioneering zones, does allow for some infringements on First and Second Amendment rights. So that provides some authority for law enforcement to say, well, you know, you have First Amendment rights, you have Second Amendment rights, but you don't have a right to intimidate people. So, you know, we'd ask you to step back another 100 feet or go to the other side of the parking lot or whatever, those type of things. We think that would be upheld under the same rationale that the no electioneering zones have been upheld by the Supreme Court. These are not questions that, at least when I was a prosecutor, that I dealt with on a daily basis. So we've been trying to do a deep dive in it to provide that kind of guidance, not only for you, but for your law enforcement.
Great, thank you. That's very helpful. Before we turn to opening up, and I see we have some questions already, and anybody that would like to, feel free to add questions to the Q&A box. I would just like to get sort of a 1-minute summary from each of you of what is the most important thing for our audience to keep in mind as they try to ensure that the jurisdiction where they are is able to be free of armed intimidation. So I'll start with you, District Attorney Torrez, and then Mary, and then Josh.
Well, I think the most important element is communication. There is the communication that you undertake internally with your prosecutors and also, I guess, with your law enforcement partners to make sure everyone is on the same page, that you have a plan in place for how to triage calls for service throughout the election. But even more important, I think, is the public communication that you engage in to make sure people understand that despite the rhetoric that you're hearing again from the White House and other places where there is seemingly this call for independent armed groups to come out and play some role, to remind people very specifically and directly that that's a violation of the law, that it's not constitutionally protected, and that we as prosecutors stand ready to take appropriate action. I would, and as a component of that, in terms of my own communication, I go to great lengths to stress this is not a partisan approach from my office. It's irrespective of your ideological beliefs. If you show up at a location intent on disrupting the rights of other people to exercise, their ability to participate in democracy, we're going to take action, and they have to know that up front. I don't think there can be any equivocation from local prosecutors that you're ready to take action. Just make sure if you're going to communicate that you actually are ready to follow through and do it.
Great, thanks. And Mary?
Yeah, I'd echo everything that Raul said, and also just want to provide yet another resource. So and this just really harkens on how this is a bipartisan issue. We have pulled together a coalition of nationwide law firms, and I will tell you, it's most of the people that are involved in this effort are former prosecutors themselves, Republicans and Democrats, who have all agreed on a pro bono basis to be available to assist local jurisdictions and those who might need help with bringing litigation, if that's, or just providing advice about armed intimidation at the polls or armed intimidation and armed activity, unlawful armed activity post-election. So we've been meeting with this group of lawyers every week to work on particularly focusing on some states that we think are hotspots to get our law together. We have our TRO standards together. So there are options beyond criminal prosecution, just as Raul's case makes clear. Some of USDAs have civil enforcement authority. Obviously, if you're in the heat of a moment, sometimes an arrest might be necessary. But if we see activity before we get to election day, either through social media planning that's clear and evidence worthy, or because of some armed individuals who might be coming out at early voting sites, that is another option, right? To seek some emergency relief in the courts to get an injunction against that. So not that I'm saying that's the best option, because there's, I think, hopefully many more options besides litigation, but I just want to let you know that ICAP has pulled this coalition together. We are available. And so if you find yourself in this position of I know a lot of you are resource strapped, most people are. If you need some backup, just please do reach out.
Great, thank you, Mary. And we will be distributing a lot of the resources that we're discussing on this call after the call as well. Josh, do you have any thoughts?
Yeah, I would say you got to know the law, and it's a bunch of different sources. It's not just one part of the code, right? So you need the election law, the open carry concealed law, the voter harassment, the criminal harassment. You got to have all of that together. We put a bunch of that together at our Guns Down at the Polls report for our Michigan, Wisconsin, Pennsylvania, North Carolina, and Virginia. There's some other resources out there, but know that. And then just like you do with voting, make a plan. Make a plan to think about what will happen if one of these things occurs. You have to be ready to move. And I think, especially on election day, this will be relatively rapid. So thinking ahead of time, we know the law, we have a plan in place. If we see that type of voter harassment, for what exactly we're going to do, so you're not scrambling on election day to help secure voter rights.
Great, thank you. And I think I just shared your report to everybody as well, that you can see in the box. What are the states that you focused on? Did you already just say that?
Yeah, Michigan, Wisconsin, Pennsylvania, North Carolina, and Virginia. And there are some other resources out there for the other states. I mean, Everytown, I think, probably has a resource. The Giffords Law Center has a resource. So there's resources out there, but make sure you're ready and you know what the law is on all those levels in your locality.
Thanks so much. So we've gotten some questions, and if you have any others for the audience out there, feel free to put them in the Q&A box. Starting with a question for District Attorney Torrez. What are the types of messages that you are delivering on social media regarding voter intimidation?
Well, something that should be obvious, and probably someone needs to deliver the same message to the president, which is you can't appoint yourself to go down and take your gun to monitor what happens on election day. And I mean, that's the most basic message. This is not a system that is unregulated. It is as Josh and Mary have highlighted, it's a highly regulated process. And so we're just reminding folks, in case they have gotten the wrong impression from national leaders or from social media, that this type of behavior, and we lay out the specific aspects of the code as well as the broader criminal statutes that may come into play. These are the penalties. This is a crime. This is how much time you could serve in jail if you're convicted of it. Please don't do it. The other thing that we're stressing to folks is that we are letting people know specifically that we are training law enforcement and that we're prepared and that we have a plan, so that they don't somehow get the impression that we will be caught flat-footed or that this behavior will somehow go unnoticed. And so it's my hope that by delivering very specific information early on, you generate confidence in the general public, but you also give the folks who might be tempted to engage in this behavior at least a moment's pause before they go and go down this path.
Great, thank you. Did anybody else want to add to the social media strategy, or is that great? We have another question from Michael Collins. When an AG and Board of Elections have jurisdiction over election integrity, what is the role of a local DA? I don't know if you want to take that, DA Torrez.
Well, so what I can tell you from my perspective is that the lead agency, the person who's responsible for this, is the local county clerk. I take my direction from the local county clerk. And we actually are going to make the same hotline that we make available for law enforcement available to her staff, so that if reports are coming out from election officials at a particular polling site, we can get that same information directly from them. But I've been very clear with her that we are going to follow her lead on understanding who has the primary role or responsibility. And it's only unless we have a report of a crime in progress from a member of the public or a designated judge are we going to have law enforcement sort of take that action that would otherwise rely or reside with them.
Great, thank you. We have a question from the chat box. If a polling place is an entity where typically any carry of firearms are prohibited, for example, a church, does the fact that it is a polling place somehow allow for carry of a firearm? I believe, Josh, you were discussing this earlier. Do you want to take that?
Yeah, so that's going to be a basis of state law, depending what the state law is. What I mean, I've investigated this in a couple places, and you're interpreting a couple different statutes, but from the way I look at Virginia law, for instance, school, where I voted a school, and there's no concealed carry in Virginia schools. It is a during business hours, right? And so our interpretation is you can't bring a gun into a polling place that's in a school in Virginia. Now, it's going to be an interpretation by location, and state by state. So it's going to be, you really have to get into what your state law says. And in the case of the laws that I'm most familiar with, there's not necessarily an absolutely clear answer to that. But there's certainly not a statute that says you are, affirmatively allowed to bring a gun into any location in a polling place. So you just have to look at the local law and do the best you can with that. But those prohibitions generally don't go out the window.
Absolutely. And I might add that it's also worth looking if there's any applicable federal law to the location. I know the Gun-Free School Zone Act might be applicable depending on, if the polling location is in a school. So also a good place to look. Next question from Tim Daly. In light of the discussion about the need for planning, Mary, has ICAP put together any scenario planning that could be shared or organized a simulation that could be instructive for key officials?
We have not, and I'm sorry to say that, and I've talked with some others about the need for that. I've been doing a lot of, presentations like this and answering questions. I mentioned the guidance we are planning to put out, and we're working with a group that just launched yesterday, voter protection program. That's a bipartisan group that's really advising a lot of state attorneys general, but they're drawing on our work and the work of other organizations, including Everytown and including Brennan Center and others about across the spectrum of voter intimidation. And we've talked with them, in fact, just this morning, about coming out with some guidance on 3 different time periods. One is sort of threats to election integrity pre-election, things like, and actually Raul was mentioning this before we started the webinar, what happens if you get reports of ballots being stolen from mailboxes? What happens if you get reports of like a box of ballots found someplace? So it's kind of what to do, who to call, what to do. Second is that like what to do in the case, as we were talking about before, of armed individuals near a polling place during early voting or an election day. And then another sort of bucket of things to do and how to coordinate post-election day. Some of the infrastructures where I'm working with different organizations to build are the ability to mobilize calls like, U.S. Conference of Mayors, major city chiefs, and National District Attorneys Association, ability to mobilize calls quickly if issues come up so that people can share their experiences and resources with others. And things like that. So this is one of those like commands, need for a command center, but we've got so many different levels of, law enforcement and election officials that it's just, a lot of people are working hard to get us all, in line so that we can have some effective communications. But we will work on getting those products out, and if time permits, maybe some scenario planning as well. We're also talking about 2 other things. Let me mention. We're talking about also maybe trying to do some videos that could be used for law enforcement training. And we're also probably going to be doing a presser next Monday. I did one this past Monday. I'm going to do one this coming Monday, but even a week from Monday, October 26th, where we're looking to have an AG, a mayor, a district attorney, a police chief, a sheriff, to all be kind of like talking about this together for purposes of the press to be able to report on what the type of planning is going on. So we don't want to alarm people and say so they won't vote, but the best antidote to worrying about intimidation is to come out in massive numbers, and we are starting to actually see that in those places that have started early voting. I think it was Raul who put it really well last week when he and I were on a similar panel, that the way we make our choices in this country is based on ideas and policies, not on intimidation and at the end of a barrel of a gun. So we just need to keep impressing that.
Great, thank you. Our final question is for City Attorney Fuhrer, who is actually going to give us some closing remarks anyway, so I will close out and just let him take the question and finish it up for us. But before I do that, I just want to thank all of you for coming here for this critically important conversation today. We'll be sending follow-up resources based on what we discussed. And if you have any other questions or would like to set up a follow-up call or meeting with our team or the other organizations, as Mary discussed earlier, represented here today, let us know. And thank you to Prosecutors Against Gun Violence, DA Vance, and City Attorney Fuhrer for setting this up. So the last question was for City Attorney Fuhrer, what concerns you might have specifically in Los Angeles, and also some concluding remarks.
Very good. So thank you so much. I will answer the question after I say a few thank yous, because my job today is to sort of anchor this by highlighting the most important points that have been made by our panelists. So first, the thank yous. We're indebted to Everytown for gun safety, and Mark, you did a terrific job today in particular. Always DA Cy Vance in Manhattan. We at Prosecutors Gun Violence, of course, deeply appreciate your leadership. Cy and I co-chair PHEV, another great job by your team in Manhattan. And of course, want to thank DA Raul Torrez, a PHEV member, Mary McCord, and Josh Horowitz, our longtime collaborator on all kinds of issues. And of course, all our colleagues at Prosecutors Against Gun Violence throughout the nation who are participating today. So let me answer the question, and then I'll do my best to summarize the essential points from today. Here in Los Angeles, we are differently situated from some other jurisdictions, which are, for example, open carry jurisdictions, other jurisdictions where legislators tend to be more deferential to claims of gun rights advocates. Having said that, however, here in Los Angeles, we need to be vigilant and assure that every single person feels free to vote the way they intend to vote. And so I've been in touch with our police chief, for instance, and who is extremely well-versed on the details of this. He has a key point person. For reporters from Los Angeles, Deputy Chief Arcos is the point person at LAPD. We're going to be collaborating very closely, in addition to working with our state elections officials, Alex Padilla, our Secretary of State. I don't have specific concerns about Los Angeles that meaningfully distinguish us from other jurisdictions. I, however, am, as all of us on this call are, very concerned that the reports of potential for intimidation be squelched at the inception by our preventative work at the beginning. And with that in mind, let me focus on lessons from DA Torrez. Some of Raul's key points for our colleagues who are prosecutors include, be sure we have convened and talked to our law enforcement partners. He has an online training that he has put together for them, really important. He's going to convene a war room. We could all take a lesson from that idea, that there be prosecutors available in the moment who are the point people in our offices, the experts, to collaborate with law enforcement and other colleagues on these issues. Raul suggested the importance of de-escalation strategies so that the first take at grappling with one of these issues at a poll need not be an arrest. It could be something that is less significant as an intervention and continues to promote the idea that all are welcome at a poll, just certain activities are barred there. And DA Torrez focused on the importance of a communication strategy. Here in Los Angeles, I've adopted that approach. All of us throughout the nation should be adopting approaches that make clear what the rules are so that everyone knows that harassment is completely off limits at a polling place. From Mary McCord, we heard some very key lessons. Lawyers speak in threes. So twice she spoke in threes. And the first batch of 3 lessons is there's no legal authority for armed militias to self-deploy at the federal level. And the Second Amendment doesn't protect paramilitary organizations, and state laws heavily regulate those organizations. Those armed extremist groups are not lawful in any jurisdiction. States regulate them. And she also offered 3 points regarding intelligence that she has heard, which include that there may be some plans by some extremist groups to identify small groups of 2 or 3 to infiltrate polling places, attempt to insert themselves. She mentioned that they might purport to be poll workers themselves, and in that manner have some authority to intervene and question the credentials of eligible voters. That, of course, is completely off limits in jurisdictions from California to those across the nation. Also, she noted increased trainings may be happening post-election for post-election activity by these organizations. And our longtime colleague, Josh Horwitz, points to various legal issues we should all be cognizant of. Every state has voter harassment laws, he teaches us. In California, for example, you can't be within 100 feet of a polling place and attempt to interfere with anybody's voting in any way. He notes that local locations, we talked about schools and churches and others, have policies that may further enhance the ability of local authorities to preclude weapons from being in a polling location. And he notes also that there are firearms brandishing laws throughout the nation that come into play as we as prosecutors evaluate how we will respond to any issues of violence or threats of violence at a polling place, any intimidation of any kind. Our friends at Everytown have a fact sheet that focuses on every state's laws that are relevant to the issues we're discussing today. That fact sheet is disseminated widely. All of us have it available to us. So what I would do by way of finally concluding is to say this. This is an extraordinary election this year. We all know it. I have never been in an election I've been eligible to vote for 40 years. I have never seen ever any hint of a federal authority encouraging in any manner anything other than a free, fair expression of voters' views, and post-election an easy and lawful and peaceful transfer of power. We know that those issues are in the backdrop here, but we as prosecutors, as law enforcement officials, have both the obligation and the ability to assure that at the polling places within our jurisdictions, there is not a hint of voter harassment or intimidation by weapon or otherwise. And today's panel made very clear we have many tools that we can invoke to assure the elections are in fact free and fair. And with that, Mark, I'll give it back to you.
Thank you so much, City Attorney Ferry. That was a perfect summary. And that's it for the program. Thank you so much to all of our panelists for joining, and to Prosecutors Against Gun Violence for putting this together. And again, there will be a follow-up email with resources that have been discussed today. And best of luck to all of you for a free and safe election.
Thank you all.
Thank you.